hi everyone, and welcome to the Art of Estate Planning Facebook Live for October 2024. We are so honoured to be joined today by Greg Russo and his huge amount of knowledge that he's got when it comes to estate planning. Greg is from Greg Russo Law in Victoria. I had a bit of a poke around, Greg, and I can see that you are on Doyle's list for recommended lawyers for 23 and 24. So good running there for both wills and estates and estate litigation. So Greg's obviously someone who his peers very much appreciate his talents as well. I believe that, Greg, how we came about is your presentation today is Tara had actually seen you present on a topic like this, and it is something that is so frequently raised in a part of our community, our inner community, about equalisation. And I think that it's so easy to get it wrong and to have quite disastrous impacts. And even if you don't get it wrong, you know, you might not get the desired outcome. So I think that today is a really big day for all of our estate planning lawyers out there that are listening in, but also for our accountants and financial planners who are the ones that are going to be crunching the numbers to see what the equalisation looks like. So, Greg, without further ado, I'll let you kick off and tell us more about effective equalisation provisions.
Thanks, Carrie. Thanks very much for that introduction. And you're absolutely right. I think that we spend so much time, don't we, in being careful to secure comprehensive instructions and to really understand our clients' family dynamics and what their intentions are. I know Tara is a massive advocate of testamentary trusts and getting them right, and you know, sort of begs the question: what's the point in having a really fantastic estate plan with the bespoke and nuanced testamentary trusts that specifically reflect the values of the clients that you've got, if you don't then populate those trusts with the appropriate assets and have a bird's eye view of being fair and amongst different parties. I understand that Tara will be sharing both my paper and this PowerPoint on various web pages, the Facebook page and YouTube, etc. Just make the point at the start that what we're doing is at the sort of the complex area of estate planning. So very happy to be giving a lot of information today and answer whatever questions come through, either today or after today. Yeah, take what I'm saying today, please, as general information and not advice. So let's sort of kick off. What I'm talking about today is this desire that a lot of testators have increasingly to ensure that their future estate beneficiaries all share in their post-death wealth in particular proportions. Sometimes it might be, you know, I want all my kids to be treated the same, or I want my daughter to have twice as much as my son because of X, Y, Z. And in order to achieve that, we sometimes have to go back to basics and think about what is going to be available, what's going to be available going to be worth, and then mechanically, how do we actually give effect to what the client is instructing us to do? Because clients have a very clear view about what they think is fair. They want to treat everyone the same. You know, everyone's getting the same, at dollar for dollar. That person's getting a house worth $1 million and that person gets $1 million in cash. They want to be fair, and they want to divide their wealth either equally or according to a predetermined formula. But it can be really complex to do that when the family dynamic is complex and when the assets are also complex. And, you know, it's just sort of worth reflecting that to do what we do well can be really, really complicated. And I say this a lot, it's hard. It's really hard to do what we do. And I communicate that to my clients as often as I can, to justify and explain my fees, to justify and explain why things take the time that they do, and to justify and explain some of the limitations in what we can do. Anyway, today we're going to have a fairly focused look at one complexity only, which is financial complexity. We're not worried about blended families or complex financial structures, except indirectly. We're simply worried about how are we going to achieve the carve up of the post-death pie, if you want to call it that, in the way that the client wants it to be carved up. So we're going to look at what it actually means when we talk about equalisation within an estate plan. We're going to look at some strategies. We're going to look at how we can forward plan at the estate planning stage to try to prevent problems down the track. We're going to look at tax and some very briefly at duties and some other financial impacts, how we manage the risks. To the extent that we have time, we'll have some case studies and examples. As with most of the presentations that I give, the focus for me is always on the practicalities. How do we as practitioners go from having a client ring up to producing a product on time, on budget, and have happy clients that are going to refer other clients to us, and so that we can sleep well at night, not worried about what might happen if we had got things wrong. So the focus as much as possible is on the practicalities of how to get things done. So I thought I'd start with a couple of case studies that we'll revisit at the end, time permitting. So this is the sort of email that I sometimes get, like 9 o'clock on a Monday morning. Hi, Greg, my name's Leonard. I was referred to you by Simon. Said you did a great job for him and Nina with their wills. We want to update our wills. Our situation's simple. Always be very careful if a client tells you that. We've got 3 adult children, Amy, Ziggy, and Marley, and we've got a home in joint names. Our bank accounts are all joint. We've got 2 cars and a dog named McTell. Want to treat our children equally when we die, and we look forward to hearing from you. So that's easy, no problems. I mean, that's the sort of thing that I'm sure every one of us would be able to process within systems that we've already got in place with our administrative staff, with our existing will templates. What about if you then got this email about half an hour later? Oh, hi, Greg. Further to our earlier email, by the way, we gave Amy 10K 10 years ago, and we gave Ziggy, 100K 10 years ago, and we gave Ziggy 100K last year, and Marley wants to inherit our home. We've got a family trust and self-managed super, and all of that has to be evened up after our death. We look forward to hearing from you. So to the extent that that second email creates some issues for you or makes you think, oh, how am I going to do that, as opposed to having systems in place where you understand the steps that are involved. Hopefully today's presentation is going to assist you in addressing those sort of concerns. And there's a case study I just wanted to set out. There's a suggested solution, a suggested response at the end of the paper and at the end of the presentation, which we'll go through if we have time. But this is the sort of thing that I think is becoming increasingly common. We've got a client, Bob. He's got a home. He's got a company that's got assets of $1 million with a cost base of $500,000. He's the controller and member of a self-managed super fund, which has a member balance of $300K with possible death benefits tax. If super death benefits are paid to a non-tax dependent of $30K. He's got a family trust which has some cash and shares of $500K with a cost base of $400,000 and cash and term deposits of $2 million. So that's not unusual to have a company, a trust, a self-managed super fund, and a bit of assets in his own name. 3 children, Dylan, Marley, and Nina. One of them financially dependent on him. And his global testamentary intentions are that each of the children receive an equal third of his total wealth. But with some checks and balances. He wants Dylan to have his home. He wants Marley to have the family trust. And he wants Nina to have the investment property. So that's, I think, a fairly basic type of situation that increasingly is going to come across our desks and our conference rooms. And to be able to understand how to move from the instructions to a solution is what we're talking about today. And that's just another way of presenting that information. I've learned how to use the art aspects of PowerPoint, so apologies for that, but there you go. That's just another way of presenting that information. And the question is, what are the equalisation considerations? How do we actually get the job done and produce a plan that we're happy with, that we don't have to reinvent every time with something like this comes along? Okay, so we're going to have a look at that at the end, time permitting. I can see we are, just about on time, so that's good. So it all starts, the start of the story, once upon a time, it all starts with taking instructions. And the first point I make is that it's critical to identify what I call a client's global testamentary intention. This is their testamentary intentions, their intention regarding their assets after their death that deals with their entire post-death wealth from all different sources. And I find, and probably the same, each of you, that testators and clients are often unsure about the extent of their post-death wealth. They forget about the life insurance, or they don't understand that the family trust will continue, that it's not simply something that can be dealt with by their will. So we need to, as estate planners, we need to make sure that our clients have considered all their current assets that they currently own, all the future assets that they might own, the assets that they control rather than own, trust assets. They're the appointer of a trust. So the assets they control rather than that they own. And also, and it's not in there, but also assets that they have disposed of before their death that they also want to have taken into account. All of those have to be taken into account, and it's our job to make sure that our clients turn their minds to that. And this is where our job starts. This is where we start communicating what a positive reason it was that our clients came to see us, because they leave the first conference. Wow. I have so many people say, wow, Mr. Russo, you've given me so much to think about. I didn't realize it was so involved. So automatically, straight from the get-go, we're communicating the value in what we're doing. And I've put this in red at the bottom. I just wanted to spend 30 seconds talking about this. Right from the word go, I think you need to challenge or clarify with your client whether a dollar for dollar equality outcome is required. So where clients want everything to be sold and divided in a particular percentage equally, or thirds, or 40, 60, whatever percent, that's easy. But where they want any of the beneficiaries to acquire a particular asset, and we're going to have to value things, or we're going to have to give super death benefits, and there might be tax and there might not. Anytime there are those sort of value judgments, no pun intended, that need to be made, straight away, I start talking to my clients about, do you need it to be dollar for dollar? I've got a matter at the moment where there's a couple of trusts, a family trust, a historical testamentary trust, and lots of other assets. And the family trust and historical testamentary trusts are of similar value, but who knows what they're going to be worth at the date of death. And my client has, with my encouragement and suggestion, moved away from requiring there be dollar for dollar parity between those two assets and the evening up from the residue, to child A gets the family trust, child B gets the testamentary trust, and whatever they're worth, it's fine. If one of them happens to be worth more at the date of death than the other, it doesn't matter. We're then just going to go 50-50 on the residue. And my client has come to that conclusion because I challenged their thinking. Is it really important that everything be dollar for dollar? And they answered, well, actually, it's not. They're both worth a couple of mil. One might be 2 point, one might be 1.9. What does it matter? So that's a really important point to make, to not be bound by a bland statement like, I want everyone to be treated equally. Ask your client, well, actually, what does that mean? Is it equal enough if he gets the asset that he wants, she gets the asset that she wants, they're of similar value, and that they go then equal on the fungible, on the cash and the other assets you can divide up. All right, so that's the first point, taking instructions appropriately. So, and then I've got 3 examples just to sort of demonstrate the differences that we can come across. So a testator might provide instructions that each of their children are to be treated financially equally after their death, having regard to assets that are available after their death only. All right, that's pretty simple. One more layer of complexity. A testator could provide instructions that each of their children are to be treated financially equally after their death, having regard to advancements made by them to their children prior to their death, together with the estate assets. That's one more layer of complexity. What about this one? A testator provides instructions that each of their children are to be treated equally, having regard to assets falling within their estate, assets distributed directly external to the estate, such as super, joint assets, as well as the control of family trusts. And that's more common, isn't it? That whatever their total wealth is, that's what they mean by equal. If one of the kids is going to get the $1 million assets in the family trust, the other one needs to be compensated. But we don't find out unless we ask. So this is a very much a ask a lot of questions phase. Here's another diagram I did, that smart art with
Greg, I
powerful.
might just give you a bit of a breath there. I think that's a really interesting point around asking clients, because I think it's really incumbent on us to actually ask open questions about where this desire for, a hot knife through the middle comes from, because often it comes from a mistreatment of them, or they felt they were unfairly sort of treated under their own parents' will. And then when you weigh that up versus, you might think this is fair, but it's actually going to be much more complex. So I think getting that open-ended questioning line is really important.
That's a really, really good point. And it's that last thing you said, Carrie. It's explaining, well, actually, if you have a will that requires there to be equality, then you're putting the obligation on the executor to get things valued. You're starting to make value judgments, or you've got the children saying, well, mum wanted this, dad wanted this, so it has to happen. Whereas if you lead from the front and say, you're getting asset A, you're getting asset B, the cash is being divided equally, they might be a little less happy about that, but there's not going to be any arguments. And the unhappiness can be dealt with a non-testamentary explanation in a will. I didn't want you to argue over, historically that property's been worth more than that one sometimes, and vice versa. So whatever the gods decide, when I die, whatever they're worth, they're worth. And it just sidesteps the potential disputes. Because a lot of the disputes I find, Carrie, after death are to do with what I think mum intended, what I think dad wanted. And it's to sort of stand in their shoes that people go to court and fight. So the more you can be really clear about what your client wants, the less that there's going to be litigation needed to justify that. All right. So this is just another way of describing the post-death wealth, and allowed me to have a bit of fun with the smart art. But the point is that a will dealing, it should be with estate assets available at the date of death alone, won't be sufficient to achieve these global testamentary intentions when we've got assets that are going to fall into the estate and assets that are going to continue or to fall outside of the estate. So that's a fairly simple proposition, I think, but it's one that we just have to keep reminding ourselves of, and it's one that a lot of our clients will not have given sufficient thought to, having come on their way to come in and see us. Okay, so then we talk about equalisation clauses, and in the paper that I prepared ancillary to this PowerPoint, I define what equalisation clauses are. But an estate plan that deals with multiple entities is probably going to require a few documents: a will, nominations in a superannuation fund. We're going to have to think about succession of trust control, and potentially powers of attorney to give effect to or maintain the financial position during a period of incapacity. All right. And so what we're talking about today, again, is pretty narrow. We're simply talking about what do you do from the perspective of your will to take into account these adjustments and the division of the bigger picture, the assets that are in the estate and that are also going to fall out of the estate. So how do we have regard to post-death wealth and pre-death advancements when we're drafting a will? What do we do within a will to enable the executor to give consideration to the bigger picture stuff? And I give during the next half hour or so, I'm going to refer to that process as equalisation. Even though we're not always talking about dollar for dollar equalisation, it might be 60-40. We're going to talk about equalisation amongst those various different sources. Okay, and I refer to the way that we do that, the mechanics of doing that, as the equalisation clauses, which I break into two different categories, which we'll get to in a moment. But let's just go back to what it is that we're doing. When we're estate planning, with experience, we get better at using the tools that are at our disposal, aren't we? So we've got lots of tools, and I know that Tara is a big advocate of testamentary trust, as am I, and that testamentary trust can promote positive tax outcome, and they can also create protective and asset protective outcomes for our clients. Not as popular, but that they're around. Mutual will contracts can promote certainty, and conditional gifts can promote post-death control. We're just talking today about just another tool like that. But to be very clear with what we're talking about and where it fits in, we're talking about equalisation clauses, and I divided them into two types. There's an adjustment clause, which gives the executor the authority, sometimes obliges an executor to change values, percentages to achieve a global intention, and valuation clauses. So in order for an executor to know how to adjust, if we're ever distributing assets specifically, or there are lumpy assets that are remaining intact, we have to value those. And so the valuation of assets is absolutely critical. If we go back to the earlier slide where we had the 3 different types of testamentary intentions, I won't go through them again, but the ones that I've highlighted blue, these ones will require some form of equalisation clause, some form of adjustment and or valuation clause in order to give effect to. All right, so it starts with instructions, getting instructions, as Carrie has indicated, asking open-ended questions and allowing your clients to work out what their intentions are within the context of that. But it then moves very quickly to will construction. And there's a very famous case, which is authority for the proposition that what a court of construction has to do. So what we have to think about is every time we do a will, it might be read or interpreted or construed by a Supreme Court judge somewhere. The judge's job will be to give effect to the intentions of the testator by looking at the words used in the will, okay, construed as a whole, and only aided by admissible extrinsic evidence. There's lots of different rules about that. We won't go into them today, the armchair principle and all that sort of stuff. But the starting point is this, right? Is that if you're drafting a will, it needs to be clear on its face what the testator's intentions are. Don't draft a will on the basis that I have my file and the court can look at my notes to work out what the will means, because it won't always be possible, okay? And if a court looks at a will and recognizes that actually the will doesn't do what, there's extrinsic evidence about what the testator wanted, the will doesn't do that, there's authority for the proposition that just because that discovery is made doesn't necessarily give the court the authority to rewrite the will. So I make this point that it's important the will is drafted to give effect to the testator's global testamentary intentions without recourse to external evidence. So when it comes to adjustments, to valuations, it should all be in the will, okay? It should all be in the will and apparent what the testator is wanting the executor to do years in the future when the testator dies. All right. And then just a bit of a diversion here, not to get too spiritual or anything, but I just sort of make the point that when I was very young and I was reading a Buddhist text, and I came across this idea that there was this group of Buddhist monks, and what they would do is they would sit in them every morning and they would contemplate 2 things. The first thing they'd contemplate is that their death was inevitable. So all of us and all of our clients, their death is inevitable. And the second thing they'd contemplate is that the timing, the occurrence of the death was completely unknown, arbitrary, could happen at any time. And I sort of think about that like we're all on a conveyor belt, you know, and there's a mist in front of us. We can't see what's coming up ahead. And the reason I raise it now is just as a reminder that it's not only hard what we do, but it's so important. It's so important that when the client leaves the office, having signed their will, that based on what we have been told, we have got the will as right as possible, that they have considered all the things that they need to consider, because you know, their death is inevitable and it could happen at any time, no matter how young or how old they are. So I just raise that as a kind of just a reminder, and I communicate that to my clients, just how important it is what we do when we're doing it on the spot, not doing a will to fix it later. Try to get it as right as possible from the get-go. So, and so what I try to do, and I'm sure a lot of you out there try to do it as well, but just as a reminder, because while we're talking in this zone, is what I try to do is to have systems in place to ensure that I get enough information. I have instruction sheets, I have checks lists, I have template documents. I think about substitutional provisions. What if that person dies? What if they both die? You know, just all of that. I tell people it's not nice to talk about your children dying before you, but let's talk about all these things and let's get as much information as we can so that we can have a complete outcome with multiple redundancies. All right. And so I've just got a very basic tool that I use. And I've got another simple situation here. So just say we've got a client, Bob. Sorry, we've got a client and the beneficiaries are Bob is to inherit Smith Street, a property, and Amy is to receive control of a trust, and that the residue of the estate is to be distributed to them equally. And then this diagram here, again, my smart art fetish now. You take comprehensive instructions, you have systems to ensure that you get the instructions, use the tools that you've got, think about substitutional provisions. And I use these tables that I've come up with. I'm sure other people use them as well, but I use tables that, and I use two types of tables. I use a table that sets out what the client wants, that's asset specific. So what's happening to each asset? Who's getting that asset? And then if that person doesn't survive, who's the substitutional person? And I have beneficiary specific tables. So they're kind of at right angles to each other. What are each of the beneficiaries receiving? Which assets are they receiving? And I try to sort of set those out in a couple of tables. And I've just taken up another slide with, here we go. Bob's going to get Smith Street. Amy's going to get a trust. The residue of the estate is to be distributed equally. And if Bob and Amy aren't around, their children receive their share. So that's a really simple example. And it's not the sort of example that we would normally worry about using complex tables for. I mean, you could just write that out in a simple paragraph or in a simple instruction sheet. But just to sort of show, and in more complex situations, I've used these tables to great effect to sort of recognize, oh, hang on, that doesn't work because of whatever. But here, you've got the top table is dealing with the assets. This is where the particular assets are going, to which beneficiary and substitute beneficiary. And then the second table, you're dealing with the beneficiaries. And it's not a bad way of just holding up a template to your draft will to make sure that the will does what you're intending it to do. Might sound like overkill, might sound a bit anal, but trust me, when you've got assets in the estate, pre-death advancements, discretionary trusts, self-managed super funds, blended families, these sort of tables, very, very useful. All right, anyway,
Great.
so that's all.
I think too, just, I mean, we're very, very, very fond in the art of estate planning of diagrams generally, and Tara, as a part of one of her products, has estate planning flowcharts which serve a similar purpose to visually set out what asset goes where on the death of the testator or the death of, both clients as well, if there's two of them. I know that one of the things we had talked about prior to this was, what level of complexity would be needed to set one of these out. But Tara and I don't know if we've started a podcast. We don't know who's listening. I hope people are listening, but we were filming one of them or recording one of them yesterday, and this came up about using these sorts of diagrams. And I think the position is, even if you don't necessarily give them to the client, doing them all the time internally for your own benefit is actually really useful. Setting something out that's in non-legal words about mechanically who gets what really helps to jog your memory later on. But then also, as I said, to circulate it then to the client is that extra value add, because most people don't want to read a 40-page testamentary trust will to work out who gets what. So I think you're right. These sorts of tables are really valuable, even for some of the small stuff.
Okay, that's a really good point. Okay, thanks for that. Yep. All right, so let's move on then to some equalization strategies. Let's jump in a time machine and just go back in time for a moment. So the different strategies that sorry, I'll just change this. Okay, I'll put that there. The way that we used to equalize was with reference to where was I there? Hodgepodge. So an old clause would be something like, I declare the sum of $100,000 advanced to my son Bob, or so much as may be owing at the date of my death shall not be charged as a debt, but will be brought into account. Okay. So hodgepodge was the way that we dealt with all adjustments and all equalization issues. And I think post superannuation, post the use of family trusts and more complex family dynamics and financial structures, hodgepodge probably not adequate to deal with the adjustment and equalization issues that now arise. Hodgepodge could be more complex than that. It could specifically reference post-will advancements and make provision for interest and extend the class of beneficiaries. But adjustment clauses, bespoke adjustment clauses, much more common nowadays. Let's stay back in time and let's think about where I think this sort of idea that you really ought to be thinking about adjustment clauses a lot, no matter how complex or how simple your client's position is, can be traced back, for me anyway, Carrie, to the very famous case of Grossman and Katz and Grossman. So this is where you've got Irvin and Evelyn Katz. They have 2 children, Danny and Linda, and the kids got on well up to a point. At the date of their deaths, Mum and Dad, Irvin and Evelyn, were both owners of assets that fell into their estate, but they were members, individual trustees and members of their self-managed superannuation fund. Evelyn dies, and Irvin, Dad, is the only one alive, and Linda is the golden child. So she becomes the executor of the will, and she becomes the controller of the self-managed super fund after Irvin's mental decline, and then his ultimate death. So he dies on the 19th of September 2003. So over 20 years ago now. And she appoints herself and her husband as the trustees of the self-managed super fund. And whatever was in the estate, the will was really simple. I give everything that I own to my 2 children equally. Right? Father loved his 2 kids and wanted equality between them. So, and what happened was, as executor of the estate, Linda divided the estate assets equally between herself and her brother. But as trustee of the self-managed super fund, and there was no nomination 20 years ago, she made a declaration pre all of the conflict cases that we've had in the meantime. She made a declaration that the self-managed super fund assets would be distributed to her. So Danny Katz, her brother, went to court and said to the judge, that's not fair. I'm getting half the estate, but my sister's getting 100% of the super, and it's all post-death wealth. And the judge said, yeah, I agree, that's not fair, but there's nothing I can do about it. What she's done is legally correct, even though it might be morally wrong, or words to that effect. So that for me is a seminal case that is a reminder, and I don't think, Carrie, I do any wills that don't have an adjustment clause. I think I might have done 1 or 2 where the client insisted it be removed. But if there is any prospect of any non-estate assets that will be available post-death, I always, as a fallback position, include an adjustment clause, something that allows an executor to look beyond the estate assets and work out residue entitlements with reference to all post-death wealth. So if we're talking about...
Why might you not use something like that, Greg? Like, what's your reasoning for saying I'm not going to use that type of clause?
If I say to a client, look, some clients really, even though we deal in the, I'm sure you do as well, a lot of people do with the sort of fixed price area. A lot of people want their will to be simple. And I've had clients that go through and just cross out, I don't want that, I don't want that, I don't want that. And then when it comes to adjustment clause, I'll say, well, if you own super at the date of death, I won't. Well, if you've got any other, life in, I won't. If you've got a trust, I won't. So if there's absolutely nothing for that clause to do and the client's adamant about it and they don't want it in, I'll take it out. But otherwise, I always say, well, why not do a will that can accommodate a change in financial circumstances? What if you become the beneficiary of a testamentary trust from a great aunt in Scotland? And, then you won't have to change your will. So, but that's the only reason, is if I'm specifically instructed. And I always recommend, Carrie, that it be included as a fallback position. And I try to bury it at the back of the will so that it doesn't impact on the dispositive provision, so it doesn't distract from those. Anyway, so an adjustment clause, if it is included, and it generally is for me, it can specify which assets are to be adjusted. It can decide whether an adjustment is to be mandatory or discretionary. Okay, you can say the executor must adjust or the executor may adjust. And it can also set out a process, which we'll get onto shortly, about how we're going to value assets. So let's have a look at a sample adjustment clause here. So this is a mandatory one, and this might be useful where the executor is also a beneficiary. So otherwise there might be issues of conflict if the executor had to decide whether to adjust or not, whether it was going to impact on their net entitlement to the estate. So this is the sort of clause where it would say words to the effect of, it's my intention, my executors are directed to ensure that the division of the remaining balance, the residue, whatever you call it in your will, takes into account, in addition to the assets that are in my estate, in addition to the remaining balance, the following. And you might say super, death benefits paid directly, the value of a family trust, whatever it is, or the value of pre-death advancements. I direct my executors treat those amounts, which we define as adjustment amounts, as if they form part of the estate, as if they have been received by the beneficiary who got them, and adjust the proportions of my estate accordingly. And then there's usually some provision for how the assets are to be valued. And then, of course, from a mathematical point of view, Carrie, we've got to think about, well, what if there's $10 million in super funds that go straight to one child, and there's only 200,000 or 300,000 in an estate? What can the executor do there? So then the last clause is basically to say to the executor, do the best you can. You know, if just get as near as you can to an equal adjustment. So just because you can't adjust dollar for dollar, don't not do the process, just do the best you can. So that's an example of a mandatory adjustment clause. And here's an example of a, going too fast. There we go. Hang on. Oh, too fast, too far. There. This is a discretionary one. So, and this is this says to an executor, in calculating the share that a beneficiary of the remaining balance is to receive, there's a wish that if the executor thinks it's appropriate, that in achieving parity and achieving the objectives I want to achieve, that they can take into account these additional assets. And then you give examples. I don't use this. I think there's no point. It's a bit like having a non-binding death nomination in a super fund, but it's in the presentation for completeness, and it does create flexibility. What it means is that you're, as an executor, so as a testator, you're giving your executor the keys to the city. Your executor really gets to decide, and so you're having the executor stand in the shoes of the client and making decisions that adjustments can be made or not made, depending on what the executor thinks. So, as I say, I tend to not include this, but there's no reason for it to be not included if if a client says, "Oh, I don't know," you know, leave it to the executor to sort out after I go. If I've got money in super, I don't really care. Yep.
Greg, I think, I mean, this places a really big weight on making sure that we're really comfortable who the executor is.
Yep, absolutely.
And whether all parties that are going to be subject to something like this are represented. I just wanted to put an alternative to you, because I mean, this is certainly what I do, and it's not required to everybody. I don't necessarily have a broad adjustment clause in my precedent. I more add it in if I think it's appropriate, rather than have it in and take it out. Is there competing arguments for one versus the other that you think are pivotal?
For having an adjustment clause in?
Yeah. So rather than have it kind of as a standard as they must be adjusted, I would only add it if I thought it was particularly important. Because for me, when I do an estate plan, I'll look at, for a particular, like a trust, for example, and the superannuation fund, those sorts of benefits, and put it as a holistic discussion, and then add it in if the client thinks that we are going to need to do that, rather than just have it as a sort of boilerplate clause in the will.
No, I think
I'm just thinking,
as long,
I'm thinking out there for all the practitioners listening, making sure that everyone knows there are different options for the way that you do it.
Sure.
And the pros and cons of each, I suppose.
No, I think it's perfectly valid. I think provided you are, and we have spent a fair bit of time already on, taking instructions, thinking about what's there, looking at the big picture, provided on each case you are putting it on the agenda and saying, okay, so what's going to happen to the trust? What's going to happen to the super? What's going to happen to the estate assets? You only need to adjust really if looking at the global picture, you can't designate now who's going to get what on a basis that's acceptable to your clients, because things are going to change in value, or because they just don't know, or because they want to leave it to the kids. So if they say, look, I don't care, provided the trust, the super death benefits, and the estate assets all go equally, then you'd need to have an adjustment clause, because you can't adjust the estate assets until you know what's happening with the others. But if the client says, no, look, Bob gets the trust and Mary gets the super, and really, I don't really care, provided they get those, everything else can just go equally in the estate, then you wouldn't need it. So provided it's on the agenda, I think it needs to be, I think the idea or the possibility of an adjustment clause always needs to be considered, and in instruction sheet stage, but whether it needs to form part of a template will or not, absolutely not, provided you're always having that discussion with your client.
Thanks.
Okay. All right. So then I've got a couple of a couple of complex clauses, and these are sort of like, warning, warning, just be careful. I think that I'm a big advocate having. We all make lots of mistakes as we learn our craft. Having prepared some really complicated wills and looking back, I think I'm a real advocate and a real believer of keep it simple, stupid. Just keep it as simple as possible, as direct as possible. Having said that, sometimes I found a lot. There were particularly husbands and wives, so couples, not always blended families, but couples where they would want, but probably more so in blended families, they would want their entire wealth, including superannuation, to be distributed as if they were just one happy family. So maybe husband has 2 kids, wife has 2 kids. When they both go, everything's to go 4 ways. And we want to take into account estate assets and also super death benefits that each of them may have. Now, depending on the order of their deaths and depending on the proximity of their deaths and depending upon whether you believe that stepchildren are entitled to superannuation or not, and that's a sort of a $1 million question at the moment. I think you got the old Superannuation Complaints Tribunal saying one thing and the ATO saying something else. But depending on where you sit with all that, there's a chance that in a very simple blended family situation, one partner's kids may end up getting superannuation directly, and the other partner's super may go to that partner's estate. So I identified a few years ago that there's probably a necessity in a blended family where people die, within 20 days or 30 days or 60 days of each other, and they don't change their will. There's probably the necessity for one will to adjust, not only with reference to super that is available because of that testator's passing, but also super that is available because of their partner's passing. If you think about assets being his assets, her assets, joint assets, his super and her super, assuming it's a heterosexual relationship as an example, if all of those assets need to be adjusted, then there is an argument that if you're going to include an adjustment clause in each of those wills, that not only should they take into account the testator's super, they should also take into account the partner's super. So to be used on a sort of a case-by-case basis if you think there's a risk of that occurring, and it's simply tweaking that adjustment clause that I talked about earlier to include superannuation death benefits from my estate and potentially from my partner's estate that are going to be distributed to our beneficiaries. So that's one example of a complex adjustment clause. And then this is another one, which is, I guess, Cara referred to as a reverse adjustment clause. And it almost, I think, feeds into the query you raised before. So just say that I've got a client and the client says, look, I want my daughter to achieve the control of my family trust. All right. And because that's happening, I'm happy for my son to get all of or the bulk of my estate assets. So what I think in that situation is that's fine. But what if the daughter doesn't get the trust, right? So then there's the ability to adjust the estate assets to give her more if the son acquires the family trust control because that wasn't consistent with the testator's intention. So here, and again, it's a more complex situation, but here I've included a clause in some of my wills where I say, bring to my executor's attention that the division of my estate has had regard to the fact that my daughter is the nominated beneficiary of my super, or my son is to achieve inheritance of control of my family trust. And then I say, if that doesn't occur, I empower or direct the executors to adjust the residue so the best that they can, we get the outcome that would have been achieved financially if that had have occurred. So again, you're giving the executor a lot of power and a lot of authority, but it's almost a sort of a reverse engineering. So it's just another example of what we can do depending on the appetite that our clients have for certainty. If I have a client and I say, look, so you've got the daughter getting that asset and the son getting the super and the other daughter's getting the estate assets, what if one of those things breaks down? If they go, oh, well, I definitely don't want that to happen, then I can talk to them about checks and balances and these more complex adjustment clauses. A lot of people say, look, I don't want to overthink it. I've done what I've done. she's getting that, he's getting that, that's the estate, that's what I want. So again, I think we've fulfilled our retainer if we give options to our clients about creating a more complex outcome, and then whether they want to or not, if they want to, we can incorporate these clauses, and if they don't, then we can confirm in writing that they haven't wanted us to use them. All right. So they're the sort of adjustment clauses that I typically use: the mandatory, the discretionary, the simple, and the more complex. And they have a place in most of the wills that I draft, but I accept that, case by case basis, they'll be used or they won't be used. All right. So we're moving now on to valuation clauses, which really are an adjunct to this process. If you're going to be seeking to achieve a certain equality or a certain proportionality between beneficiaries with reference to estate assets and or non-estate assets, if there are going to be lumpy assets, if there are going to be assets that are going to be transferred in specie, you do need to have some sort of way of valuing what each of the beneficiaries are receiving. All right. So, and that valuation process I make clear on this slide, and you'll see from when we look at a couple of the cases, can be very challenging. Okay. The first issue is that there can be taxation and cost issues. Now, I know that Tara's reach is national, so stamp duty issues vary from state to state, so local advice is necessary. But also, there's that general idea that if an asset passes under the terms of a will, if it's a CGT asset, you get rollover relief if it's passing pursuant to the terms of a will. Easy. If, however, you want one of your beneficiaries to inherit an asset and you give them an option to acquire, to buy that asset from the estate, then the executor sells the asset to the beneficiary, and the beneficiary pays for the asset, and it's the proceeds of sale that become the estate asset. Then there are arguments that that tax will be payable and potentially stamp duty will be payable. So the way that you draft the provision that facilitates the provision of a lumpy asset directly to a beneficiary can have implications to the estate and to the beneficiary on a revenue basis. And the point I make in the paper that accompanies this slide, this PowerPoint, is just make sure you've thought about that. And even if you're pretty confident that there won't be tax, or even if you're pretty confident there won't be stamp duty, make provision for, if there is, who pays it. Is it a beneficiary expense or is it an estate expense?
I
So
think
let's have a
just Greg, to give you a breather, I think that's one of the things I know Tara and I talk about all the time, that it's really hard to get a true equalisation from, a tax perspective, including future tax consequences of something. So that's one of the issues that we've historically had with kind of general equalisation clauses. Certainly, and I'm sure your paper covers off on some of those issues as well. So if you're looking for some of the detail, Greg's going to be kind enough to share his paper as well. But I didn't know what your thoughts were on that, Greg, but I'm assuming, as you said, it's more so just then covering, well, who covers off on those liabilities.
Yeah, that's right. I mean, and it is really hard that you can't think of everything. You can't, in a will, avoid any potential claim that could possibly be made, particularly as we're all getting so litigious and everyone's so entitled nowadays. But you're absolutely right that to the extent that there might be taxation, I think, number one, work out whose liability it is, and as we're talking about now valuation, work out whether, if Carrie, you're getting the investment property and I'm getting the home, how are we valuing those? Are we taking into account latent CGT that you might incur if you sell the property, or are we not taking that into account? And that was the very issue that was raised in the recent South Australian case of Todd and Todd. So this is where you've got Joan dies as a widow, and she's got a will dated 2006, appointing her 4 kids, Alex, Wendy, Bronwyn, and Yvonne, as executors, and lots of properties, lots of specific bequests, and a clause that said, at the finalisation of the administration of my estate, all of my said children will have received an equal value of bequests under this my will. That was her intention. Wonder what value of bequests mean, tax, net of tax, and all benefits given by this my will and any codicil shall be paid, delivered, or retained free from all duties whatsoever, which shall be paid out of my estate. So not a bad clause, and you kind of think as a lawyer that you've done a pretty good job. But ultimately, the court was asked, what does it mean? And the court held that the value of the three properties should not depend on the tax affairs of the person. So kid A got, Alex got one property and Yvonne got another property, and then ultimately the testator saying fill in the blanks and make sure that everyone's getting the same. So the properties all had to be valued, and so the court said, firstly, the value of the properties should be something that's coming from the testator and not dependent on the tax affairs of the person to whom they bequeathed. And the ordinary meaning of value is that each property is valued as at the finalisation of the estate at what a person wanting to buy the property would have to pay, willing vendor, fair market value, because none of the properties were being sold. So we had to come up with a value. And that latent CGT was not to be taken into account. And one of the justifications for the court saying that was that if one of the beneficiaries was in a higher tax bracket, their latent CGT liability would be higher than another beneficiary who was in a lower tax bracket. And that was too arbitrary. But again, this is a fairly, academic, legalistic interpretation. It probably would have been simpler if the testator had said, don't take latent CGT into account, or take it into account, or came up with a formula. So, I think the will drafters did pretty well, but it didn't avoid litigation. And I've just got a takeaway that failure by a testator to provide clear directions in a will may result in uncertainty, and it makes sense to consider the potential tax liabilities that might apply either to a transfer to a beneficiary or to a beneficiary ultimately selling the property. But as will be seen now, even if you've got a really good equalisation clause, I think, Carrie, we're all getting so litigious that there is no guarantee now that we're going to avoid litigation. Before we go on to Craven and Bradley, which is a Victorian case, let's just have a think about if we're saying to a client, okay, you've got lumpy assets, specific gifts passing to particular beneficiaries, let's talk about how those assets are going to be valued. Let's put a mechanism in the will to give your executor direction, so the beneficiaries understand what your intentions are. Then you should be thinking about when the value will take place, because someone dies on day one and the estate's administered 12 months later. Valuations can fluctuate. How? Sworn valuation. If it's a business, it's going to be more complex. Appraisals, are they okay? And what are we going to do with latent CGT, the status of taxation liabilities? You might have to put in place bespoke considerations in relation to particular assets. Company assets, do we take into account tax that will be paid on dividends that will be paid from the company? Do we take into account death benefits, tax on superannuation death benefits? And there's also a couple of things to sort of keep up our sleeve, that if all beneficiaries in an estate are over the age of 18 and managing their own affairs, there's case law that says whatever they decide is fine, so they can bind and release and protect an executor from liability. And in each state, there are statutory provisions that provide a fallback method. In Queensland, I think it's in the Succession Act, and in New South Wales, and in Victoria, it's in the Wills Act. So again, it comes down to making it as clear as possible what the intentions of the executor are, of the testator are, and then setting that out in a will. The next case of Craven and Bradley has a beautiful valuation clause. It's really well drafted, but it wasn't sufficient to avoid a very motivated plaintiff issuing proceedings. Phyllis passes away. She's survived by Ian, Bruce, and another son, not particularly relevant to the facts. Under her will, she gives her residuary estate to her three sons in equal shares, but subject to a couple of properties being devised to the plaintiff. He gets one, and Bruce gets the other. So one property each, and then everything being evened up. Okay. There's a home, which is CGT free, and there's an investment property, which is subject to CGT. Okay. And there was a tax equalisation clause that dealt with taxation that would be payable in respect of the properties. It dealt with latent CGT, but it still wasn't enough to avoid litigation. So the clause in relation to the home was the value of the property will be determined by registered value on terms that would be granted to an arm's length purchaser from the estate. And the clause in relation to investment property was the value of the property will be determined by registered value on terms that would be granted to an arm's length purchase from my estate, less an amount equal to the capital gains tax liability my estate would pay if the property was sold at the date of my death. So it was all fairly clear and fairly comprehensive. And the court was asked to answer these questions. Should CGT in respect of the investment property be calculated on what the estate or what the deceased would have paid? Because they were two different numbers. The plaintiff calculated those and said, oh, well, the estate has the benefit of these marginal tax rates and so on and so forth, and the deceased would have paid this and the estate would pay that. And should the home be valued at the date of death? So there was an argument about when, and there was an argument about what tax would be taken into account. And the court held, the plaintiff lost on both counts. The court held that the reference to capital gains tax liability was a reference to the liability the estate would incur if it sold the property during the administration, and that the phase of the estate, and that the home should be valued at the date of death. And the court just reinforced this idea about will construction and said that reading a will is like reading a contract. And we ignore subjective intention, and we've got to look at what the testator's intentions are with reference to the will itself. Back to what I said before about getting it right in the body of the will. Read as a whole, and a court isn't entitled to rewrite the will. Court has to basically read what the will does and is bound by that. Even if it suspects that the testator doesn't mean or didn't mean what ultimately the will does. So the takeaway here is that you can have a really well drafted, and I encourage you to find the case on Ostley or wherever, read the equalisation clause. It is a really well drafted clause, but you won't be able to tell your clients, and I tell all my clients this, that I'll do the best I can, but there is no guarantee that we'll be able to avoid litigation. Because if proceedings are going to be issued, they're going to be issued. I think what happened here is because the clause was so well drafted, the appropriate outcome, a more certain outcome, the plaintiff possibly shouldn't have issued proceedings really on balance, looking at the big picture, but did. We won't be able to prevent proceedings being issued, but hopefully with a really well drafted equalisation clause, taking into account taxation and other matters, the risks of an adverse outcome or uncertainty in litigation are likely to be minimised. Let's have a look at one last case before we go back to the case studies. Otto and Redhead, which is a Queensland case. Okay, Beryl Otto, 2 kids, Glenn and Brett. Her estate includes shareholdings in 2 private companies, and each of the sons was gifted shares in one of the 2 companies. So they each get shares in one company each. The will had an adjustment clause, and the adjustment was with regard to the value of both estate and non-estate assets that had to be taken into account to achieve parity. She said 2 kids got to be treated the same, please. Okay, and the clause directed that the assets were to be valued at the date of the deceased's death. So that was done, but what happened is that the estate is administered, the shares aren't transferred during the administration phase, and during the administration phase, one of the companies, the shares in one of the companies escalate, so that we get to the end of the administration phase, and one of the sons is actually getting a lot more, potentially, if he takes those shares, his shares, than the other son because of the market valuation in the meantime. And the question was, do we value the shares at the date of the deceased's death or at the date of the end of the administration of the estate? And the court held that the deceased's intentions were absolutely clear. The valuation was to be undertaken at the date of her death. But the deceased was really clear, another really good adjustment clause, a really good equalisation clause. The will was really clear that she wanted her sons to be treated equally. Okay. And because her will allowed for post-death advancements to be made, to be taken into account, the court was able to determine that the increase in the value of the shares in the company that went up was a post-death advancement. And so that son had to account to his brother for the increase in the value of those shares. Now, whether or not that's ultimately what she would have intended or not, that's what the court found in this case. And I guess the takeaway here is that a well-drafted and comprehensive adjustment clause like that was here, like there was in Craven, can promote certainty of outcome, but it will not always avoid litigation. And I think it's important for us to realise that even though we draft really good wills, thinking about all the things we need to think about, good file notes, good paper trail, we won't necessarily be able to guarantee our clients that their future estate will be litigation free. All right, so we're right on the hour. I'm just going to run through very quickly, Carrie, if we've still got time, this sort of revisit this case study that I gave at the start. So if you just remember, we've got Bob's got a home, he's got a company, he's got a self-managed super fund, he's got a family trust and cash, 3 kids, Dylan, Marley and Nina. Nina's financially dependent. Each child is to receive a third of the total wealth represented by the estate assets and the non-estate assets. Dylan's to get the home, Marley's to get the family trust, and Nina's to get the investment property. And the question I ask is, what are the equalisation considerations? And so the first point to make is, well, there's the tables. So I've drafted up tables that you know, as a sort of a way of organising ourselves. And I think it's probably right, Carrie, that a really good process, a good methodology is to try to do that even in simple cases, just to sort of get yourself thinking the right sort of process, the right format in no matter how simple or how complex matters are. And I guess the first takeaway, the first point to make is that when considering equalisation issues, make sure we've got enough instructions. We could ask for further instructions from Bob because arguably the case study doesn't provide enough information for us to go off and draft documents. How are we going to value the investment property for the purposes of Nina's share? Are we going to factor in latent CGT? Are we going to factor in tax consequences in declaring a dividend from the company to Nina in the future? So how is that going to be? Because that investment property is owned by a company. And it doesn't really matter. There's no right or wrong answer. But if the client is asked the question and can make a value judgment, and that's recorded in the will, then it reduces uncertainty. Is it the gross value or the net value of the super death benefits that's to be utilised? You know, death benefits tax, the 2% Medicare levy, if that's applicable. What are we taking into account? And how is the family trust going to be valued? That's a really big ticket item, isn't it? Because you've got assets owned by a family trust. The assets aren't passing. It's the control of the trust that's passing. So they're the sort of questions we could ask Bob in order to provide further advice to him. And then looking at the sort of the big picture, again, sort of feeding into what Carrie raised before about wills, adjustment clauses, and looking at things individually, we could look at this estate plan being addressed with a super nomination distributing benefits to Nina. If she's a tax dependent, that's going to be good for everyone. Succession of trust control documents, either within the will, external to the will. Read the deed, see what the deed says about that. How do we secure control of the trust? And then the will then as a sort of a standalone document, but being able to see the trust and what's happening, being able to see the super, being able to see the investment property. So then the will gives the home to Dylan, gives the shares investment property to Nina, notes that super death benefits are to pass to Nina. And if we want, we can do one of those complex adjustment clauses to say if she doesn't get the super death benefits, then there's to be an adjustment in her favour. Noting that the family trust control is to pass to Marley, and then providing a mechanism for valuing those gifts. And then once those values have been ascertained, using the residue to even up amounts that each of the kids are going to get. That's one answer to that. And I sort of suggest, and I sort of put to everyone, that's not such an uncommon situation to have a client come in with 3 or 4 entities plus an estate and different tax scenarios for each of their kids. So look, in conclusion, we've had a look over the last hour at some of the equalisation options that estate planners have available to them, and the importance of getting things right from the start, of really understanding what it is that a client is saying when they're saying, I want to treat all my kids the same, or I want him to have twice of what she's getting. Be really clear about that they understand and we understand what it is that they're saying. And the use of processes, tables, template instruction sheets, and approaching, I really like Carrie's idea that you approach simple matters and complex matters all the same. You just go through the same process, prepare those tables, do the same job over and over, no matter how complex or how simple things are, obviously then with different outcomes, but the same process. And so as a final takeaway, that it's probably this, that the challenges that are presented by the necessity for us to consider equalisation issues in order for us to do our job well. And you're subscribing to this channel, you're following Tara, we're all interested in doing the best that we can, clearly. So the challenges that are presented by that, they also present significant service delivery options and opportunities for us. We can separate ourselves from the solicitors out there that aren't giving consideration to these things. So in order for us to stay frosty and at the top of our game, we shouldn't be seeing the necessity to adjust as only a complexity and a problem, but also as an opportunity to really define the level of our service delivery. So thank you very much for listening. Thank you, Carrie, for the opportunity, and thanks for the questions during the course of the presentation.
No worries, Greg. Appreciating we're running over time. If anybody has any questions they want to consult with Greg about a particular case, Greg Russo Law is where he's at, and you can find his details online. We will share, as I said, the slides and the presentation. Other than that, we're going to end things there. Thanks so much again, Greg, and everybody for listening.
Thanks, Carrie.
Take care.
Cheers. Goodbye, everyone.